This whole idea that these regulations are going to put our kids in jail and behind bars is completely unfounded. She was a Dalit girl in Rajasthan who was raped on campus in an institution by her professor. They had been consistently complaining to the college authorities to they were complaining about the harassment.
Universities are spaces of learning, ambitions, and opportunities. But for many students, especially those from marginalized backgrounds, campuses can also bring along exclusion, silence, fear. In the past decade, India has witnessed a troubling pattern: discrimination on the basis of caste, creed, religion, and gender of students, often leading to even deaths. And what's worse, on the institution's part, there's often denial and inaction. At the center of one of the most significant legal challenges to this silence is advocate Disha Wadekar. Disha has spent years working on cases at the intersections of caste, gender, and institutional accountability. She has represented several families in cases of student deaths, until one case reshaped the national conversation about discrimination in higher education. It was the Payal Tadvi case. Payal Tadvi was a junior resident doctor, a tribal woman, the first in her family to pursue postgraduate medical education. But in 2019, she died by suicide. Her death sent shockwaves through the medical community.
Justice. Payal's mother and her husband, who was also a doctor, Salman, and Payal's mother, Abida Tadwi, they had been consistently complaining to the college authorities they were complaining about the harassment that Payal was facing from her senior resident doctors. And the complaints were specifically about the targeted discrimination that she was facing from her upper caste senior resident doctors. There were many letters and representations that they wrote to the head of the institution, the dean, the authorities. And all of this is on record. It's a part of police record. It's a part of public record.
Then in March 2016, a 17-year-old girl was found dead in a tank at her college in Bikaner's Nokha district in Rajasthan. Her parents alleged rape and murder. It was also alleged that she was subjected to discrimination based on her Dalit status.
I have also represented the family case. It's important to take his name because she was a Dalit girl in Rajasthan who was raped on campus in an institution by her professor, right? And then her body was found in a tank, right?
For Wadekar, the Payal Tadvi suicide case raised a question larger than criminal liability. What happens when institutions ignore early warnings? As the legal proceedings continued, Wadekar began looking beyond a single case. She discovered that universities already had regulations meant to address discrimination.
We found these equity regulations 2012. They had been there all along. We were in 2019 when we were researching, and we found that there was something like the equity regulations. None of us had heard about it. Most people that we spoke to did not know that these 2012 equity regulations existed. Most people, even now, who are talking about these equity regulations still don't know that they have existed all along since 2012.
But in reality, these either did not exist or existed only on paper.
So we filed RTIs before the UGC and we got this huge data, like thousands of universities. Okay, and UGC had asked them to implement the regulations, but the college and universities were not doing anything. 50% of the colleges and universities were not even responding to the question of whether they have implemented the equity regulations, right? And then this data showed us that there was complete institutional apathy as far as the regulations are concerned. Most colleges in their replies would say that we had zero complaints. We don't have any complaints of discrimination. We are an amazing campus. The few of them who would say that we received complaints would say that how have we resolved these complaints? We have sent the complainant for mental health counseling. And we compared these two regulations because they have very specific focus. One is on sexual harassment and prevention of sexual harassment. The other is prevention of ragging. We realized that the sexual harassment regulations and the ragging regulations had much more stringent procedural mechanism. UGC has powers under the UGC Act to also enforce the laws or the regulation. So for instance, UGC has powers to withdraw grants from institutions that do not comply with their regulations, right? Or UGC has powers to withdraw the affiliation of colleges or universities that do not comply with the regulations. Or they have powers to de-recognize courses because they also give grants and recognition to courses to universities. So with the use of all these powers, UGC is effectively able to enforce its regulations. And we realized that the equity regulation had no such enforcement mechanism. So we went to the court with two prayers. One was that, look, these regulations exist, and therefore we went to the court saying that the regulation should also be strengthened, right, in this manner.
The absence of functional redressal systems meant students were often left without nowhere to turn. That failure became the foundation of a petition before the Supreme Court of India. The petition asked the apex court to examine why existing safeguards were not working and direct UGC or University Grants Commission to strengthen and enforce them.
UGC notified the regulations in January of 2026, right? 13 January 2026, they notified the regulations. So this has been mostly the journey of how these regulations came about. It is very clear that it is not something that one fine day UGC decided to do, because the regulations were already there for them to look at and change or amend or strengthen all these years. It is very specifically there is a specific push because of the court's orders in the Abhida Tadvi Radhika Vimula petition. And to our surprise, when we saw the regulations of 2026, UGC had in fact made a lot of changes, good changes. As far as the definitions is concerned, let me be very clear that the newer regulations have diluted the definition of caste-based forms of discrimination. See, as far as the enforcement mechanism is concerned, which is a third aspect, the older regulations did not have any form of enforcement mechanism, which is why these regulations were being flouted by universities left, right, center. Nobody cared. So in the new regulations, you have a non-compliance action clause where now UGC can take action against any university that does not comply with its regulation. Monitoring mechanism has now been introduced. So there's going to be an oversight of, there's going to be a monitoring committee.
But this was not a small fight.
This is something that went on for 6 years. There was obviously zero, I would say, financial support to sustain this litigation. So I've had a team of 10 people working on this, right? And they're all people who are working for free, working pro bono, putting their labor, putting their time in this. And a lot of times I've had to put my paid work at the side to be able to do this litigation and sustain this litigation for the last 6 years.
But there was also another cost to pay: targeting.
So any time you work on issues like discrimination, whether it's caste-based, gender-based, any form of discrimination, you do face targeting from a certain section that feels like, oh, but this is something. They don't look at it as a protective legislation to protect a certain group, but they look at it as a legislation that is targeting them.
So when the University Grants Commission eventually notified new regulations that mandate all higher education institutions to form equity committees to look into complaints of discrimination, committees that must include members from scheduled castes, scheduled tribes and other backward classes besides women and specially able persons, the backlash was swift. And claims that the new UGC rules would discriminate towards gender category students, blame upper caste students as potential perpetrators of harassment, and eventually criminalize students in faculty triggered widespread protests.
What I can tell you from people's responses is that they from the responses, I feel that the regulations have not even been read properly. Firstly, this whole idea that these regulations are going to put our kids in jail and behind bars is completely unfounded. These are completely regulations that operate in civil realm. Okay. No equity committee has the power to put someone behind the bars or to incarcerate someone.
Punishments, Disha says, are proportionate. Apologies, undertakings, transfers, suspensions in extreme cases. Criminal proceedings remain separate and require FIRs under existing laws.
A suicide is a suicide that is defined under IPC. You will have to lodge an FIR, right? So if a penal provision like suicide is attracted, you will have to anyway report to the police authorities. I feel like there is a lot of misinformation around how these regulations are only meant for SC, ST, OBCs. That is not the case. That's complete and utter lies. Neither the 2012 regulations nor the present regulations are only for SC, ST, OBC. 2012 regulations and the 2026 regulations, both these regulations specifically talk about caste, gender, religion, race, place of birth, disabilities. All the axes of discrimination that are defined in Article 15 of the Constitution of India. It's the same axes that have been again reiterated in the regulations. So I am not understanding the selective outrage against the inclusion of caste-based discrimination.
For Disha, the outrage revealed a deeper discomfort. She draws parallel with earlier moments in the Indian legal history.
This is also a backlash that every protective law we've seen in this country has faced, whether it's the sexual harassment regulations where you had like all the men's rights activists up in arms and they were like, oh, we're all going to go behind bars. When we were only talking about civil remedies, right? Or the Domestic Violence Act, where all the men were like, So, and the Atrocities Act also, where everyone is like, oh, atrocities are going to be misused. Every law, for that matter, is prone to misuse, right? Something so basic and elementary as theft provision in IPC is prone to misuse. So, does that mean that we do away with the theft offense in IPC?
She says the idea is fairness, not punishment without process.
I myself, when I was, doing my law and I was doing my graduation, I have felt so much exclusion and so much discrimination in that university space. At times, I think about what if, when I was in college, I had an equal opportunity cell or a redressal mechanism. Maybe things would have been different. Maybe I wouldn't have been so scarred.
The case was never just about regulations. It was about the absence of listening.